do not forgive. We do not forget. Expect us.
Concern yourself not with my real name, or my physical mask. Concern yourself only that for now, I have chosen ethics and morality, and chosen a physical mask over a digital one that comes more naturally. I am Nomen Nescio. Rights are not privileges.
So, hey, how's everybody doing today? Hope everyone is doing well. Um, Had court this morning in Gary for my arrest back in July, and also my arrest back in uh, Labor Day weekend of this year, so September 1st. Okay. Basically, um, I just wanted to go over a few things that occurred today. So, first of all, I want to start out by saying that I have probably one of the best attorneys that a person could possibly want. Okay, um, this guy is absolutely awesome. This is the I'm going to read to you the documents in a few minutes here that he submitted to the court this morning. And then explain to you what's going on and the process is going to need to occur. Um, but as I start to go into everything, I just want to say hello to everybody. Hi, Wendy. Hi, Bama. Here's News Now. Hey, what's up, man? Thank you all for stopping in and taking time out of your day to check this out. Okay. And then before I'm done, I'm going to bring up the website for the attorney that's handling this. And if you all feel the need to send an email in to them, to him, letting him know, what an awesome job he's doing, things like that, you can feel free to do so. Please, though, do not call the office that for something like that. You can feel free to submit a contact form, email, something like that. That is just fine. But otherwise, please do not call the office. All right, especially for something like that. Now, if it was a complaint, whatever, then that would be fine. But for something like this, an email is just fine. But people should be congratulated for the good things that they do too. It's not just the need to complain. So anyway, let me go ahead and go into this. First of all, in July, I believe, of this year, I was arrested at the O'Bannon Building on Broadway in Gary, Indiana, for failure to ID originally, um, and then they changed the charge to violation of a protective order and battery of bodily waste. So that's the eventual charges. Um, I was never served with the protective order or anything like that. So first of all, it wasn't valid. Second of all, they had to charge me with something after already cuffing me to get my ID because I refused to ID. Um, and they knew that the refusal to ID was a secondary charge, and it wasn't even valid in the given situation, even if it was a primary charge. Um, which it couldn't be. So that one they believe will be dismissed anyway. They're just waiting to do both of these at the same time. Now, as for my Labor Day arrest on 9/1, when I was arrested in front of my home for filming the police, um, the basically it should be a dismissal. It should be a dismissal. Nothing was wrong. Nothing. I wasn't doing anything illegal. However, as the prosecuting attorney said, the supervisor of the prosecutor attorney said this, that, basically whatever he puts on paper for reason for dismissal is basically what's going to go in the paper. So they're trying to save face a little bit, try to mitigate the damages as much as possible. And so, because of that, they're basically wanting to do it like this, where my attorney had to submit the motion to suppress the arrest and any evidence obtained. And then, um, basically, now that that was submitted today for that case, the prosecutor has 30 days to respond. After that, if they submit a response, then my attorney has an additional 15 days to respond to that response. All right, and then basically what happens after that is it will either be a motion for dismissal will be set, or it will be dismissed or by the judge, or then the it'll go to trial. So those are basically the three options. But let me go ahead and go over this. There's about 6 pages here, 2 pages for the motion to suppress, and then you have the 5, maybe 5 pages of the memorandum for the motion to suppress. Whoa, 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 whoa. There we go. All right. Ooh, just keep jumping all over the place. All right. So there we go. Now, I'm suspecting that these documents should also be published publicly. If you were to go to mycase.in.gov, type in my first and last name, it's going to be one of the several top cases. All right, yeah, there's like a laundry list there, but anyway. Um, You can reference it by the cause number here, right here. Okay. Anyway, so motion to suppress, arrest, and any evidence obtained. The defendant by counsel respectfully requests that this honorable court suppress Strauss's arrest, suppress Officer Jones, Officer Nelson, and probationary officer Kirk's testimony, and suppress any evidence seized, and in support thereof states the following: that on September 1st, 2018, Officer N. Jones and Officer Nelson of the Gary Police Department and probationary officer D. Kirk were dispatched to the 4200 block of East 11th Place, Gary, Indiana, in reference to a disturbance. Hey Boomer, what's up, man? Nice of you to join us, thank you. Upon the officers' arrival at the residence, as they were speaking with the complainant, the officers observed the defendant, Edward Strauss, as a bystander walking on a public sidewalk in front of the residence. The officers indicated that the probable cause affidavit that they observed Edward Strauss holding a black metallic object along with the object with a flashing light. The officers then approached Edward Strauss and inquired as to what he was doing. Edward Strauss responded that he was filming the officers on his cell phone. The officers then ordered Edward Strauss. What did I do? There we go. Okay. The officers then ordered Edward Strauss to identify himself, and Edward Strauss responded by stating that he was not committing any crime and that he was permitted to film the officers. Subsequently, the officers arrested Edward Strauss for disorderly conduct and resisting law enforcement. As provided in the Seventh Circuit case ACLU versus Alvarez, the court determined that audio-visual recording of police officers is entitled to First Amendment protection. ACLU versus Alvarez, and then the citing. As Edward Strauss's action of filming the officers was legal, the officers conducted a warrantless stop and search of Edward Strauss. The warrantless search was an unreasonable search and seizure in violation of his Fourth Amendment rights under the United States Constitution and Article 1, Section 11 of the Indiana Constitution. Now, this is all written by my attorney, which is highly shocking. I mean, trying to get an attorney to even bat an eye at the Constitution or mention violations of the Constitution is like pulling teeth, but it seems like it's just fluent tongue with this guy. So, states, additionally, not allowing Edward Strauss to continue filming the officers and the seizure of Edward Strauss's cell phone were restrictions on his Fourth Amendment rights under the United States Constitution. Any evidence seized as a result of this illegal search and seizure should be suppressed as fruit of the poisonous tree. Contem- Contemporaneously filed with this motion to suppress pursuant to Rule 3 is a memorandum in support of the motion to suppress. Additionally, attached to this motion is unedited video of the arrest of Strauss. Wherefore, defendant prays that this court grant the motion to suppress, preclude the officer's testimony and any evidence seized from being introduced as evidence in the cause, and for all other just and proper reliefs. Signed, my awesome attorney, Christopher Schmidgall. Yes, it was filed. Boomer, that was filed this morning. It was already filed this morning. I'm not sure how long it will take the clerk's office to upload a PDF copy to the docket itself, the CCS, but that's why I wanted to, put this on there. After this, I'm going to be uploading it to a Google Drive, and either that or my server, one or the other, and I'm going to put a link to this PDF in the description of this so that anybody that views this later, they can actually view the PDF copy. Just in case the video is going a little too fast for them or whatever, they can view the copy themselves, read it, in their own time. And then this here is the defendant's memorandum in support of the motion to suppress, which is, I thought the motion to suppress was awesome. This is even better. This is absolutely just a billion times better than the first one. So, comes now defendant Edward Strauss by counsel, my awesome attorney Christopher Schmidgall, and in support of his motion to suppress, submits defendant's memorandum in support of motion to suppress. Statement of facts. On September 1st, 2018, at approximately 8:30 p.m., Officer N. Jones, Officer Nelson, and Probationary Officer Kirk were dispatched to the 4200 block of East 11th Place, Gary, Indiana, 46403, in reference to a disturbance. According to the probable cause affidavit, upon arrival, the officers spoke with the complainant and other party involved when they first noticed the defendant, Edward Strauss, walking on a public sidewalk near the location of the residence. Strauss happened to be walking on a public sidewalk near the entryway of the residence. The officers indicated in the probable cause affidavit that they observed a black metallic object with a flashing light. Officer Jones then stepped away from the complainant and the other party involved to speak with Strauss. Officer Jones then asked Strauss what was in his hands. Strauss responded by stating, "I'm YouTubing live." Strauss was recording the officers from the public sidewalk near the residence of the initial complaint. As Officer Jones approached Strauss, Strauss began to walk backwards towards the other side of the public sidewalk and continued to record. Officer Jones then ordered for Strauss to state his name and provide identification. Strauss responded by stating that he was not doing anything wrong. Officer Jones then told Strauss that he was interfering with the police. Strauss did not respond and continued to record the officers on his cell phone. At this time, Officer Jones ordered Strauss to stop recording and to identify himself, to which Strauss responded that he was not committing any crime and had the right to record the officers. The probable cause affidavit indicates Strauss began to shout that he was not committing any crime and that he knew his rights. Subsequently, the officers arrested Strauss for disorderly conduct and resisting law enforcement. Argument. Any and all evidence obtained by the illegal arrest, search, and seizure of Strauss and any testimony of the officers in this matter should be suppressed because Strauss was permitted to record the officers pursuant to the First Amendment of the United States Constitution, and any evidence obtained by the illegal arrest, search, and seizure should be suppressed as fruit of the poisonous tree, as Strauss's Fourth Amendment rights were violated. Violation of Strauss's First Amendment rights. Strauss's rights under the First Amendment of the United States Constitution were violated when the officers interfered with his right to freedom of speech, specifically recording police activity. In ACLU v. Alvarez, the ACLU challenged Illinois' eavesdropping statute, which made it a crime to use an eavesdropping device to hear or record all or part of any oral conversation without consent of any party. The issue of the case was whether the First Amendment prevented Illinois prosecutors from enforcing the eavesdropping statute against people who openly record police officers performing their official duties in public. The court stated that in the act of making an audio or audiovisual recording is necessary, included within the First Amendment guarantee of speech and press rights as a corollary of the right to disseminate the resulting recording. The court found that restricting the use of an audiovisual recording device suppresses such speech just as effectively as restricting the dissemination of the resulting recording. The court continued by stating that the audio and audiovisual recordings are communication technologies, and as such they enable speech. Criminalizing all non-consensual audio recording necessarily limits the information that might later be published or broadcast, whether to the general public or to a single family member or friend, and thus burdens First Amendment rights. The court concluded the audio recording is entitled to First Amendment protection and found that the Illinois eavesdropping statute restricts medium of expression and interferes with the gathering and dissemination of information about government officials performing their duties in public. In this case, Strauss' recording of the officers is protected speech by the First Amendment. Strauss was recording the officers while they were performing their official duties in public. The officers were at a residence with regards to an incident they were dispatched to. Strauss happened to be in the area and began to record the officers from a public sidewalk where he stood as a civilian bystander. Strauss's activity of recording the officers was permitted and not unlawful activity, as an audiovisual recording is protected speech by the First Amendment. After the officers approached Strauss and noticed that he was recording their activity, they ordered Strauss to stop recording. The officers who repeatedly demanded that Strauss stop recording because he was breaking the law. By the officers ordering Strauss to stop recording their activity, the officers suppressed his speech and restricted the dissemination of the resulting recording. Additionally, the officers removed Strauss's cell phone from his hand when they arrested him, which was another violation of Strauss's First Amendment rights because they suppressed his speech and restricted the dissemination of the resulting recording. Therefore, the officers burdened and infringed upon Strauss's First Amendment rights because Strauss did not commit any unlawful activity by recording the officers. Any search and seizure thereafter is a violation of the Fourth Amendment. Violation of Strauss's Fourth Amendment rights. Strauss was legally recording the officers when Officer Jones approached him, physically removed his cell phone from his hand, and conducted a search and seizure that resulted in an arrest. Strauss did not commit any crime by recording the officers, and therefore the search and seizure was illegal and Strauss's Fourth Amendment rights were violated. Article 1, Section 11 of the Indiana Constitution and the Fourth Amendment of the United States Constitution protect people against unreasonable searches and seizure. Indiana Constitution, Article 1, Section 11, U.S. Constitution Amendment 4, the Fourth Amendment states in relevant part the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now this next part here is interesting. I wasn't aware of this case, I don't believe, but I have taken note of it now. It does sound vaguely familiar, so I may have glanced at it once or so, something like that. But otherwise, in King v. City of Indianapolis, the United States District Court for the Southern District of Indiana found that there is a clearly established right to be free from warrantless seizure of a cell phone. King v. Indianapolis, the court further stated that this right is especially clear where an individual was video recording police activity and crime, but was not himself engaged in unlawful activity at the time the phone was seized. The court also stated that the right to be free from warrantless seizures is an obvious and clearly established right. The fruit of the poisonous tree doctrine is one facet of this exclusionary rule of evidence, which bars the admissibility in a criminal proceeding of evidence obtained in the court of lawful searches and seizures. Hill versus State. In this case, Strauss was not engaged in any unlawful activity. At the time he was searched, Strauss was recording police activity on his cell phone with regards to an incident that occurred at a nearby residence. Strauss was standing on a public sidewalk near the residence while recording the officers. Strauss was standing on a public sidewalk recording the officers as a civilian bystander and was not interfering with any police activity at the residence. As discussed above, Strauss is recording the officers as well established First Amendment right, and he is permitted by case precedent and the United States Constitution to do so. Because Strauss himself was not engaged in any unlawful activity, he had the right to be free from any warrantless searches and seizures. Under the officer's mistaken belief that Strauss had been committing unlawful activity, he was illegally searched and seized, and his Fourth Amendment rights were violated. In sum, Strauss was illegally arrested, searched, and seized, and any evidence obtained from that illegal search and seizure should be suppressed as fruit of the poisonous tree. Hey Cindy, how's it going? Thank you for joining in. I appreciate it. So in conclusion, based on the foregoing law and analysis, the evidence seized was the product of an illegal arrest, search, and seizure. Strauss was permitted to record the officers in accordance with case precedent. By the officers ordering Strauss to stop recording their activity infringed upon his First Amendment rights to speech and dissemination of that speech. Because Strauss was not engaged in any unlawful activity, any and all evidence obtained by the officers during the illegal arrest, search, and seizure should be suppressed as fruit of the poisonous tree. Therefore, this court should grant Strauss's motion and order that the arrest and any evidence seized be suppressed. Respectfully submitted, my awesome attorney, Christopher Schmidgall. Alright. So that is the motions that were filed today along with the memorandum. Basically, then, like as I said before, my attorney, will this lawyer also be filing a federal case? You know what, dude? I have asked him if he will file my federal case. And he doesn't, he was very honest with me. He told me he don't have time for it. Because he is very respective of his caseload. And because of that, he said that he could not take the case on. You know, his law office is really small. He doesn't have the resources to do it. He doesn't have the time to do it based on his caseload. So Froggy, no, to be short about it, he said no, that he couldn't do it. I mean, it would be awesome. I would love for him to do this. I mean, I would give the dude like 50% of the take for him to do it simply because of how good of an attorney he is. I mean, this guy, he's awesome. Now, what I'm going to do is I'm going to bring up here alright. Let's see. Should be showing. Let me see. Yeah, I'm Froggy. I am in the process, you know, and also I did say that if they were to, because of the financial situation that the city of Gary is in, okay, it doesn't do the citizens of the city any good if I were to just file lawsuits in both of these instances, okay? In both of these, and there's a possible third instance in which I may have a third lawsuit against Gary. So, if I were to do that, if I were to file all of these myself and win all three of these, then basically I am hey Justa, thank you for coming in. Then basically I'm doing the city the citizens of the city a disservice because I'm taking money away needlessly that could be used for benefiting the community. And that's not the purpose. All right, that's not the purpose in doing this at all. It's about accountability. And because of that, like I've told them, that so long as I'm satisfied with the result of this whole situation, so long as I'm satisfied, then and I believe that those that need to be held accountable were held accountable, then at that point, um, I will not file the lawsuit. So, um, so for a dollar and a public apology, well, I mean they have insurance that covers up to. I mean, I believe their deductible is $10,000. Normally standard, it's $10,000 deductible. But either way, so basically, it's just one of those things of I don't want to hurt the community, but I want accountability. A very public apology. Yeah, I know, right? So, on the 3rd of February is the Public Civil Commission, the Police Civil Commission, something like that. It is on the 3rd of February at 3:30 Central Time, and I plan to broadcast live from that meeting, and that is when that commission will accept um, uh, the charges, that the verified complaint that was sent over from the city attorney's office and from correct, Cindy. But I mean, that's when they're going to accept the verified complaint that was sent over by the city attorney and the chief of police. So how that process goes is that um, I was told that by IA that they submitted to the chief. The chief can suspend someone without pay for up to 5 days. Anything more than that, and it has to go to the Police Civil Commission, and then they can sanction further or whatever, but it has to go through that process if they want more than 5 days. So, and as of right now, as far as I'm aware, the verified complaint was only submitted um, about the Officer Jones. All right, Officer Off. But otherwise, thank you very much, Indy. I seen that. Thank you very much for sharing. Um, so now, as for Probationary Officer Kirk and the Supervisory Officer Nelson, I haven't. I mean, apparently they're being brushed under the table, which I don't think should happen. So unless they do something with them, then I mean, they still might get the lawsuit because it's not just about Officer Jones. Yeah, she's the one that initiated the interaction, but Probationary Officer Kirk was completely out of line, and then Supervisory Officer Nelson, he was definitely out of line. He was the head officer on scene. He was in charge of Probationary Officer Kirk. He allowed the situation to get out of hand. With all of his years of training, he should have known better. He should have stopped the situation, and he should have maintained a higher standard in that situation. He did not do that, and he allowed it to happen. He allowed Probationary Officer Kirk to bend my wrist, to cause damage to both my neck and my hand. And because of that, I believe that Probationary Officer Kirk definitely, and Officer Nelson should be also held accountable. So, I mean, it's not over and done with simply because they want to make an example out of her. You know, but anyway, so what's on screen here is the attorney that's handling my case, Christopher Schmidgall. Christopher Schmidgall is a very awesome attorney. The website is Schmidgall.com. Okay. Schmidgall.com. I don't know if y'all can see it. You can't. Alright, give me a minute. I'm going to put it in the chat. Copy. Paste. There we go. Weichschmidgall.com. Alright, and if you all want, you could, like I said, don't call if you want to tell him what a nice job he's doing, tell him what an awesome attorney is, whatever, that's fine. Do it, but email it. You can click the email us link, you can go all the way to the bottom and click the contact us link, submit it that way, okay? Do not call his office, okay? I'm sure they handle tons of calls every day. He is dedicated, he is a dedicated public defender, all right? And, you know, he's very busy. His office is very busy, okay? So, hey, Shelly, thank you for joining in. Appreciate it. So, I mean, if you all want to call this guy, call his office, then that's perfectly fine. Let people need to know when they do a good job. And so, I mean, go ahead. I tell him every time I see him that, you know, he's doing an awesome job. You know, I love what he's doing. Okay. But don't, please don't call the office. Please don't call the office. Okay. If you want to submit it, as I said, go to the website. Either click email us or go to the contact us. That takes you to the same page. All right. And you can submit it that way. You know. Hopefully, if he sees that there are more people that support the things that he is doing and the difference that he's making by sticking up for the rights of citizens that had their rights violated, in the way that he's doing for me, then he will, he might change his mind. He might, be willing to get into some of these federal cases and, help out that way too. But, everybody has their niche, everybody has their specialty. And his is sticking to grassroots right now and helping those who, you know, otherwise would not have somebody there to help them. So, I just, if you all have any questions, let me know. One second. I'm going to put this up. Get rid of that. Alright, let me bring... there we go. Okay. So, if y'all have any questions, please let me know what questions you might have, and I'll go ahead and answer them if I can. How do you get to Indy from Ann Arbor? Ann Arbor, Michigan. I don't remember where that's at. Oh yeah. Dude, that's up by Holland, I believe. You might be able to talk with Cindy Moore and see if she might be able to pick you up from Ann Arbor there and bring you down this way. I know she comes down this way. If you could get a little further south, then I could come up and pick you up, Justa. Oh wait, the top chat's on. There we go. There we go. If peeps don't start going to get a precedent against the law, nothing will change. You want to take away the qualified immunity. Bring back the guillotine. So, alright, well, if there are no questions, then I guess I will go ahead and end this. I thank you all very much for tuning in. I appreciate it. Thank you all very much for your support. Okay. If anybody's watching this that once this ends and you have questions, please post them in the comments. I try to read every comment, and I will get back to you. So, alright, well, thank you all very much for tuning in. You all be safe, and remember to flex your rights, and you have a great day.